was that took you there. You were out to get whoever it was that was called to the scene as a result of your mother's own phone call, and you were out to get whoever worked at the hospital. That led in turn to the charges in Grace Harbor District Court. Now, as I've often said over the years that I've been a judge, this is my 19th year of being on the bench on this level, we don't require a whole heck of a lot of people to come to court, but we do require you to come to court. There would have been no warrant for your arrest as a result of what happened in the district court if you'd simply gone to court. But as reflected in your own version of events given by the taped interview, you chose, for whatever reasons, not to go to court when required by the district court. The end result is there were warrants for your arrest. Going back to the day that you came down to Grace Harbor, and excuse me, I have a cold, I hope I don't lose my voice. Going back to the day that you came down to Grace Harbor, and for lack of a better way to put it, cased the courthouse, when a corrections officer was summoned and followed you around to see what you were doing and what you were up to, you knew there were warrants for your arrest. You knew that if the officer accosted you, and you knew that if they found out what he found out what your real name was, that you were liable to end up in jail. So what did you do? You faded quickly away from the courthouse, and that day you got away. The second time you came down, the day that the shooting and all the other incidents happened here, you came down here, as far as I'm concerned, with premeditated design to break into courthouse offices, ostensibly to steal files. And that's a ludicrous scheme. In this day and age of computers, the idea that you could somehow get into the courthouse, take the prosecutor's file or the district court file, and then somehow erase the idea that there's a warrant is nonsense. They don't go away just because you take the physical file. They're still there. There's still a computer record of everything that's done. So that was a ludicrous idea in the first place. Secondly, you premeditated it. You came down here with a briefcase or a satchel. In that satchel, you had a change of clothes. I can only surmise that the reason you had the change of clothes was because you fully intended, after you'd broken into the offices, in case you had been spotted, in case you had been discovered, to change your clothes, which ultimately you did do, so that you wouldn't be the same person that was recognized at the courthouse in the event that you were apprehended or seen. That you also had the knife. Mr. Arcuri talks about, well, you had the knife for the defense against dogs. That, in turn, is what you said on your tape recorded statement. However, the one thing that was self-evident at the time that this trial was presented was when that knife came out, when you were accosted by Deputy Dowden and by Judge Edwards, the knife came out very, very rapidly, and you had no hesitancy whatsoever in stabbing both the deputy and Judge Edwards with that knife. So I reject the idea that you had that knife for defensive purposes. As far as I'm concerned, you had the knife for offensive purposes. None of this had to happen. Absolutely none of it had to happen. There was no rhyme or reason for this cockeyed scheme that you had to come down here, break into the office, get the files, and somehow spirit them away. I don't know what kind of delusion you were operating under, but it certainly was a delusion. Just as much as a delusion that somehow the people in Grace Harbor County have it in for you. Nobody has it in for you, Mr. Kravetz. You're just a nuisance. You're a nuisance to Grace Harbor because you're not in any way, shape, or form doing what's expected of somebody in your position. You're charged with a matter in district court, go to court. Take care of the matter. If you take care of it, there's no warrant for your arrest. When you're in the courthouse, identify who you are, there's no warrant for your arrest, you don't have a problem. It's not against the law to come to a courthouse. It's a public building, as Mr. Menefees pointed out. But it's also a place that people come when they expect that they're going to resolve their differences and their difficulties peacefully. They're going to do it through court proceedings, or they're going to do it through something other than fisticuffs, a knife attack, or for that matter, a shooting. I don't think that Deputy Dowden had any idea what was about to befall her when she initially approached you in the lobby down on the first floor. There was no reason whatsoever for you to attack Deputy Dowden except for the fact that you knew that if she found out who you were, the name would get radioed in, you'd be discovered to have warrants, and you'd probably go to jail. So what was your response? Your response was to attack her. You got your arm around her neck, you stabbed her, and quite frankly, if it wasn't for the intervention of Judge Edwards, I think you probably would have killed her. In my view, after listening to the trial, Judge Edwards, quite frankly, saved her life. And I think that's commendable on his part. He also ended up getting stabbed himself in the process. And again, I think you very well knew what you were doing. Mr. Arcuri at trial argued, well, he didn't mean to do this, he didn't intend to do that. The front door was right there. Back in those days, the front door of this building was wide open. If you wanted to break off the engagement with Deputy Dowden long before you pulled the gun and shot her, if you wanted to break off the engagement and long before you stabbed Judge Edwards, all you had to do was to go out the front door. It was It's a very simple process, and you've done it before, because you got away from the corrections officer 2 weeks earlier when you were down your case in the courthouse. The whole thing didn't have to happen. None of this had to happen. You didn't have to be in the position that you're in. Mr. Arcuri says, well, you've got all kinds of mental issues. I'll grant you that the testimony was that you have a number of mental issues. I also think you're delusional. I also think that you're obsessing, because that clearly came through in the testimony that was presented. But unfortunately, Mr. Kravetz, you're also very dangerous, because there's no doubt in my mind that were you not before the court today in handcuffs and in a situation where law enforcement is here to keep you from acting out, that you would easily act out again. I suspect if you were out in the public, given an opportunity to do something like this, you would clearly do it again. I don't think your mind ever stops working. I think you're constantly scheming and planning and designing a way that you can possibly escape, possibly assault somebody else, or do anything you can do to get your way. As far as I'm concerned, it's not going to happen. The prosecuting attorney has pointed out that the standard range here for count 2, which is the assault in the first degree, 129 to 171 months, plus a 60-month enhancement for the firearm. They have asked that the court find, based upon the jury's conclusion that there were aggravating factors, that sentence is insufficient, and that, in essence, you get an exceptional sentence of an additional 117 months. On assault 2, they're asking for top of the range, which is 20 months, plus the 12 months for the deadly weapon. On the other one, they're talking about 364 days, which is a maximum before that, which is a gross misdemeanor. Quite frankly, I think all of the requests made by the prosecuting attorney have merit. I think under the circumstances, Mr. Kravetz, one of the things this court needs to do is to put you in a position where you're not going to be capable of hurting anybody for a very long period of time. I also think that if and when you do see the light of day as a free man again, it's under circumstances where you're so old and feeble that you can't possibly do something like this over again. This was an attack, as far as I'm concerned, on the public, on the citizens of Grace Harbor County. Mr. Arcuri says, hey, it's just a courthouse. It isn't just a courthouse. The courthouse, again, is a place where people come to resolve their differences. I dare say that there's not one person who works in the Grace Harbor County Courthouse who came to work that Friday expecting that their entire day, and for that matter, their lives, for as long as they continue to work here and even beyond, would be as seriously disrupted as they were by your actions. None of which, as I've already said, needed to take place, none of which needed to happen. Under the circumstances, I'm granting the prosecutor's request for an exceptional sentence. The court imposes a sentence on count 2 of top of the range, 171 months, plus I'm adding an additional 69 months to that, plus a 60-month enhancement. That should total a total of 300 months by my calculations, which, if there's any misunderstanding about that, is 25 years. On count 4, which is the assault 2, 20 months plus the 12 months for the deadly weapon enhancement. On count 3, the disarming the officer, 364 days. The time is concurrent on counts 2, 3, and 4. However, the firearm enhancements and the deadly weapon enhancement have to be served consecutively, and they're both consecutive to the time imposed on count 2, 3, and 4. With respect to legal financial obligations, I'm unsure, Mr. Arcuri, if you're agreeing or disagreeing with the figures that were set forth in Mr. Menefee's pre-sentence report, but it appears to me that at the very least, the financial obligations would include reimbursement of a $200 filing fee, a $500 crime victim assessment, attorney fee to be determined by separate order on billing, a $1,000 jail fee. I don't have the figures for service and process fees. I assume the state will be submitting those. Those will be ordered. As far as restitution is concerned, there's $30,325.78 to the Department of Labor and Industries. There's a $1,200 expert bill to be paid, $1,421.07 to the Grace Harbor County Sheriff for damaged and lost equipment. All of those, plus whatever other figures are submitted with respect to attorney's fees and service process fees and any other expert fees that we haven't received heretofore, will be included in the amount of legal financial obligations. Your legal financial obligations are ordered to be paid at a rate of not less than $25 per month starting 60 days from today's date. Lastly, I'm granting the request that was made by Mr. Menefee that you're to have no contact whatsoever with Polly Davitt, other than perhaps in her official capacity if she's still working as a deputy when you're released, if ever. Linda Foster, Jackie Wilkins, Watkinson. Also Rita Zastro, and you're to have no contact whatsoever except in any potential official capacity with Judge David Edwards. Have I left out anything?
No, you're
right. Mr. Arcuri, do you have any questions? Oh, one other thing I didn't say. Lest there be any misunderstanding, and depending upon what happens with respect to any appeal of this, I find that any one of the factors, either alone or in conjunction with one another, found by the jury as aggravators, would in and of itself justify the exceptional sentence imposed by this court. Mr. Arcuri, anything else?
I'm unclear. You indicated that you were following the state's recommendation, but I don't believe the sentence you announced was the same as they recommended.
It wasn't.
Okay.
Following their recommendation for an exceptional sentence.
I just wanted to make sure I had the numbers right.
No, they asked for 30 years, I'm imposing 25. And quite frankly, the reason I'm imposing 25 is because I think with Mr. Kravetz being required to serve what he's required to serve by the time he is released, if he is released, he should be sufficiently aged and sufficiently feeble that I don't think he can come back and do anything like this again.
And I apologize, and I do not intend to banter words with the court. I believe you sentenced, I heard you correctly, to top end 171 months.
171 months is the top end of the standard range, plus 69 months exceptional sentence,
Right.
plus the 60-month firearm enhancement.
However, there is another 12 months that has to run consecutive.
I'm aware of that.
So that would be,
That's the other count.
right, so, okay, so
You add them all together, it works out to 300 months, I believe.
the 312 total, I believe, because the 12 months on count 2 has got to run consecutively, the 300 on count 1, for a total of 312, if I did that math correctly. I just want to make sure we get it right, the way you ordered it, because I don't want to see this come back.
Then that's what I would say.
Thank you. I want to make sure the math is right on the form, because I know there's an organization in the state that does nothing but add numbers, and they're not real good at it.
I assume you're referring to the Department of Treasury.
No, I'm the JNS folks who review judgment sentences. You're familiar with, they send natty reports, and they're rarely correct on their understanding of the law.
I'm familiar with their letters.
as a condition of community custody,